Hi, everyone. Thanks for joining us for today's webinar, a comparative look at Canada's points-based immigration system and how it impacts families, diversity, and low-wage workers. We will get started in just a few moments. In the meantime, please use the chat box to introduce yourself and let us know who you are, what organization or office you're affiliated with, and where you're joining us from. Thank you. All right, we're going to go ahead and get started, and I'll turn it over to my colleague, Megan Esahad.
Hi, everyone. Thank you so much for joining this congressional briefing titled A Comparative Look at Canada's Points-Based Immigration System and How It Impacts Families, Diversity, and Low-Wage Workers by the Value Our Families campaign in collaboration with the Congressional Asian Pacific American Caucus and the Congressional Progressive Caucus. Thank you so much to CAPAC and the CPC for promoting this event, and to our Value Our Families campaign members who co-sponsor the event and are listed on the slide here. So the Value Our Families campaign exists to protect, preserve, and strengthen the family-based immigration system, and to promote an immigration system that is informed by love, empathy, and justice. We're a network of local and national community-based and advocacy organizations who reject attacks and propose harmful changes to our current family-based immigration system. So just before I introduce the speakers, some housekeeping. Please chat any questions you have in the chat box as we go along, and we'll ask them at the end. We are recording this, and we will share the recording, the slides, and any resources that are mentioned in a follow-up email. We have three great speakers on our panel today. First, we're very lucky to have Angelica Salas, Executive Director of the Coalition for Humane Immigrants' Rights, Los Angeles, or better known as CHIRLA. Angelica has transformed CHIRLA into a mass membership immigrant-led organization that empowers immigrants and their families to win local, state, and national policies that advance their human, civil, and labor rights. Angelica is a longtime leader of the immigrants' rights movement nationally. She was instrumental in the formation of the Fair Immigration Reform Movement, or FIRM, and currently serves on the executive committee. After Angelica, we'll hear from two Canadian immigration lawyers, Will Tao and Lou Jansen Dangzalan. We're very appreciative to have them volunteer their time to educate us about their system, as they don't really have much skin in the game when it comes to US policy. Will is a Canadian immigration and refugee lawyer at Edelman & Company. He provides legal services in Canadian immigration and refugee law, and is heavily involved in advocacy within the context of family sponsorships. Will also advises temporary foreign workers and provides strategic advice and consulting to a variety of institutions on immigration, refugee, decolonization, and race inclusion related issues. His blog, Vancouver Immigration Blog, recently won a 2019 Best Law and Commentary Blog in Canada award. And Will is currently co-founding the Aranis Foundation, a nonprofit advocacy, research, and education organization. And Lou Jansen Dangzalan is a barrister and solicitor with LJD Law Professional Corporation. Lou got into immigration because he himself is an immigrant. Before settling in Canada, Lou spent time in Singapore, the US, and France. His exposure to different systems and culture deepened his appreciation of cross and multi-jurisdictional issues, especially immigration law. He blends his knowledge of immigration law with his personal experience in the system to the benefit of his clients. He also has experience working in employment law and aims to bridge the needs of his immigration law clients in the Canadian employment context. With that, I'll turn it over to Angelica.
Thank you so much. Welcome, everybody. Thank you so much for joining us today to have this conversation. As has already been described, my name is Angelica Salas. I'm the Executive Director for CHIRLA, the Coalition for Humane Immigrant Rights. So CHIRLA is a California leader with national impact, and we are a membership-based organization that seeks to create a just society fully inclusive of immigrants. And our work is to advance the civil and labor and human rights of our community. I want to explain our immigration system the way I explain it to our members as they're trying to understand this very complex system. The way I describe it is to really divide it into 4 simple categories. And those 4 categories are tears, sweat, blood, and diversity. And so let me begin by talking about tears. And what do I mean by that? I'm talking about humanitarian immigration. In history, this country was seen as a beacon of hope for the world, a place where refugees and asylum seekers could seek aid. I know that now we're instead in the face of child abuse and family separation, that we know that this must end. However, humanitarian entry into the US continues to be an important part of our immigration system. It is a means by which to ensure that people who are fleeing their homeland, their country in fear of their life, have a place to seek refuge. And next, sweat. What I mean by this is legal entry through labor visas. During this day and age, we hear a lot about work visas, mostly from the tech industry. But America's past also established essential labor visas for nurses, doctors, and the Bracero program of the 40s and the 50s. In fact, my father and my uncles came to the United States first as part of this Bracero program. These programs can also be deeply problematic and lead to exploitation of workers if they are not crafted and monitored and really held accountable the way they should. But most of these visas are tied to a particular job in order to stay in the US and be denied. In many instances, most of these work visas only support the worker, and rarely do they have an opportunity for the family to also join them. This leads to our third category, which we talk about blood. And I don't mean blood in the biological sense, but in terms of familial ties as defined by kinship. Family is such an important part of our identity, and it has been a core of our immigration system since before the country's founding. Family fosters immigration integration by helping provide and support in countless and intangible ways to immigrants. And lastly, diversity. This is the value that we hold that says that through diversity visas, we want to invite into our country individuals from different parts of the world, because that makes us a stronger country. And so these diversity visas are available for countries that are not represented in any other way through the ladder. So in 1965, the family immigration system was formally centered in our laws with the enactment of the new Immigration and Nationality Act, or the INA. Currently, around 65% of documented immigration is based on family. Pre-COVID, just over 1 million immigrants received green cards each year. Out of roughly 700,000 that are family-based, 50% adjust their status within the US and 50% are new arrivals. Roughly 500,000 of the family green cards are for immediate relatives. These are spouses, minor children, and parents of US citizens. There is no quota on these visas. The rest of the family-based green cards are so-called family preference, or non-immediate relatives. This includes spouses and minor children of green card holders, adult children, and siblings of US citizens. These visas are subject to the quotas, both based on the type of family relationship and also the country of origin. Due to the limited number of non-immediate family member visas, usually this is about 226,000 a year, and the 7% cap on the total number from each country, there are large growing backlogs of family members waiting for their turn to receive a green card. The current backlog for family visas is over 40 million family green cards. The INA remains an imperfect law, and it has been the subject of attack since the very beginning. In 1990, while the number of visas was increased, new restrictions were placed on some family immigration. More recent immigration reform proposals have contained more provisions that would chip away at specific family ties, and that means adult married children or siblings. The Trump administration has waged war against the current family system by seeking rules changes such as public charge, slowing application for legal permanent residency, and citizenship. One idea, the subject of today's briefing, is that has been floated in the past and now is championed by President Trump, is to switch from our current immigration system to a point-based system, or a so-called merit-based system. In our analysis, we believe that a merit-based system its roots are privilege and racism, and simultaneously will be promoting sexism and automated discrimination. Central to all versions is a decreased value placed on family, even in cases where family ties are allocated points as part of an overall evaluation of a person's worth. Even if a merit system is initially designed to be family friendly, it could be devastating to the work that has been done to increase diversity in the US. Due to the criteria that are commonly used in these systems, they would award privilege and result in discrimination based on race and gender. By putting a premium on education, for example, many women from developing countries would be automatically at a disadvantage. The policy may be different, but the result would be the same as pre-1965, where we would have less women of color. Our fact sheets highlights more examples of this. Since the NAA was updated in Congress in 1965, it has helped increase diversity in the immigrant population. Pre-1965, 75% of all immigrants to the US were white Europeans. As of 2018, immigrants are 50% from Latin America, 30% from Asia, 10% from Europe, and 5% from Africa. Though these are great strides, there continues to be much work to be done. The system to legalize family members continues to lag and results in the aforementioned backlogs. The definition of family is too static. While we had removed the racist national origins formula until the recent Muslim in Africa bans, the system retains country quotas. Some Mexicans or Filipinos have to wait for decades to reunite with their family members. And so we have to reduce these backlogs. So we need more waivers. We need to eliminate country caps, expand the definition of family, and ensure the spirit of family reunification is strengthened in our immigration system. Lastly, right now, with over 500 children in our custody who cannot be reunited with their parents, you're faltering in the spirit that family unity is core to who we are. So immigration, from our perspective, immigration must continue to be centered on all, certainly humanitarian relief, labor and labor visas and support from that for our essential workers. It also has to move forward diversity, but we must maintain immigration that is centered on reuniting families. With that, I just want to conclude and pass it back to you.
Thank you so much, Angelica, and I'll turn it over to Lou and Will.
Hey, Lou, are you there?
Hey, yeah, sorry, a bit of a technical glitch. I think I'm in.
Okay, sounds good. Why don't you get started, and then we can proceed.
Fantastic. Hi, good afternoon, everyone. My name is Lou Dang's-Allen, and I'm joined by my good friend and colleague, Will Tao, over in Vancouver. I'm in Toronto, and before I begin, I'd like to acknowledge that we're in the traditional territories of the Mississaugas of the new credit, and we take advantage of this opportunity to thank them for being guests in their territory. Will?
Yep, and I'm speaking today from the Coast Salish territories of the Musqueam, Squamish, and Tsleil-Waututh Nations. and also they are the stewards of our land, and you know, immigration has had such a negative impact on Indigenous communities, and something that we constantly reckon with in our work. Okay, so today's presentation is also being brought to us by the through the Awareness Foundation, a new nonprofit that we're starting, and we want to do more research and focus it on from migrant communities for migrant communities, just to give you a foundation on that. Today's presentation will be in 3 parts. We're going to look at an overview of the Canadian immigration system. I don't know about you, LJ, but when Angelica was mentioning so many different aspects of the US system, I was thinking about the Canadian comparison. So we're going to try and touch on her points as well, just because so many resonated with us in the way that our system is moving in parallel and also different directions at the same time. We're going to look at part 2, the pros, cons, and a comparison to the US system. And part 3, we're going to take a more critical lens at some of our gaps and the issues that we believe of race, gender, and inequality that we believe that our Canadian immigration system perpetuates. And finally, we hope to leave 10 minutes for a Q&A. We also have an appendix near the end for some resources, additional resources that we recommend to accompany our presentation. So to begin with an overview, I'm not going to spend too much time on the next slide on the players and the sources of law. Each one of these will have a US parallel, but the one thing to just see is just the number of individuals and stakeholder organizations involved as players in immigration, from IRCC to CBSA, which is our enforcement, US CBP and ICE combination, to the Ministry of Economic and Social Development that does the labor market impact assessments, to provinces, which is equivalent to states, that are also heavily involved in providing support for permanent residency in Canada, are equivalent to the green card. We have tribunals that are heavily involved in issues of inadmissibility and also refugee protection claims. And then we have a federal court that oversees all of this on a judicial review basis. Unfortunately, as we go further to the tribunals and definitely to our courts, you will see a underlying whiteness, especially in the representation. When it comes to sources of law, we're very similar in that we have our equivalent to the INA, the IRPA, the Immigration Refugee Protection Act. We have regulations as well. Case law and jurisprudence definitely analyzes and breaks that down. But we're definitely also seeing what the US is seeing, with an increase in written and sort of online website policy updates that don't go through a formal legislative amendment process, but are really updates that the policymakers make that then have major impacts on the law. Next slide, please.
Right. Thanks, Will. So in discussing permanent residence options, it's actually really interesting. Angelica mentioned, those categories that she has, and it sort of resonates a bit with the Canadian system. So you have in 3 large groups the economic programs. You also have the family class and the refugee and humanitarian classes. Just going to go through quickly some of the important ones, but some of the salient features of the economic program is, you can see it's actually the largest program in the screen right now, is that the express entry has 3 subcategories, which were originally programs on their own: the federal skilled worker, Canadian experience class, and the federal skilled trades. So what these are buckets essentially in the larger program called express entry, which is the Canadian points-based system currently that was instituted since 2015. There's also regional and pilot programs that are in play at the moment. For example, the Atlantic Immigrant Program, and various provinces would have agreements with the federal government on them nominating potential and viable candidates for permanent residents who would settle in those provinces. And of course, you also have the startup visas, and there's also the self-employed person. Self-employed person, the closest thing that you would have in the US would be the EB visas. But then you also have the caregivers. And that's a program that's lasted for over 100 years now, taken so many iterations and went through so much history. Have an article that I can share if you want. And then we jump into the family class, and you'll see that there's a lot of parallels with the US, and the differences essentially lie in the details. But essentially, you have the ability to sponsor immediate family in the categories of spouses, common law partners, and conjugal partners. And Conjugal partners is a unique category. I don't believe that exists in the US. That stemmed from same-sex marriage or the lack of it around the world. So essentially, a lot of Canadians are now, or when it was introduced, are able to sponsor their spouse or their partners, even if they're not married, as long as they can prove conjugal relations. And then you can sponsor dependents, and then other dependents meaning those who are over the age of 21, but have to meet a certain category or requirements, such as not being able to establish financial viability on their own, and they have to have some form of disability. And finally, under the family class, you have the parents and the grandparents category, which uniquely, as opposed to the US for parents anyway, there's a cap. And this is actually determined every 2 or 3 years through the levels plan. And then finally, there's the other relative, which is essentially what we call the Lonely Canadian program for sponsorship, wherein a Canadian citizen or permanent resident can sponsor someone from outside Canada who is a member of the family class, but not an immediate family listed on this particular graph. And then the third category, very briefly, you still have the refugee obligations, the resettlement obligations of Canada by convention. And for those who don't fit into any category, but are here in Canada for the most part, or those who deserve permanent residence, and it's an exceptional remedy, it's the humanitarian and compassionate ground. Moving on to the next slide, the temporary residence options, you have 3 groups again: visitors, international students, and workers. So the general rule for visitors is that you have to have a visa to enter Canada unless you're an enumerated country in the schedule and the regulations, wherein you would require an electronic travel authorization. And the analog to the US would be the ESTA system. The other carve-out exception is that United States citizens, not nationals, but citizens, they do not require a visa to enter Canada, nor do they require an ETA. And then, of course, this is an oddity in the visitor system in Canada. You have the super visas for parents and grandparents, which was a band-aid solution, quite a symptom of the failure of the family class reunification programs, because since there was a huge backlog for the processing of parents and grandparents to be sponsored in as permanent residents, the Canadian government under the Harper government, they instituted a program wherein they can come in for a period of at least 2 years, and they can extend in Canada while they're inside, but they're not permanent residents. They don't have the usual rights that permanent residents would have, and they would have to purchase their own private insurance. Then there's international students, largely comparable to that in the US. We'll touch on that a bit later. And then there are workers. So to come to Canada as a worker, you usually would need a work permit unless you're exempt. But then if you get if you have to apply for a work permit, you would need to do a labor market impact assessment application, or rather the employer would. This is largely in parallel with the US labor, what was it called, Will? It's the LCA. And of course, there are work permits that are labor market impact assessment exempt, such as those covered by international agreements, the Canadian interest, and other exemptions. I'm not going to go through each and one of them, but I would like to touch on 2 things here that are very important, that are critically different from the US. So spouses of skilled workers who are on a work permit in Canada, they're able to apply for what's called an open work permit, a work permit that doesn't require a labor market impact assessment, and that they can work for any employer that they wish. And it's usually tied to the work permit of the principal applicant. And then, of course, there's the other work permit, the C-42, which is that spouses of international students in Canada, generally speaking, if they're in the right school, in the right program, they are able to apply for work permits on their own as well. And it's also labor market impact assessment free, and it's usually tied to the international students permits. Next slide.
So in Canada, as opposed to the US quota system, what we have is our government announcing levels plan. So they usually do this over every a 2-year period or a 3-year period. So I provided the latest levels plan for the 2019 to 2021. We have charts and tables later breaking down the proportions, so you'll be able to see more visually the difference between economic, family, and humanitarian and refugee. I loved how Angelica framed it in the US context. But you'll see here that our system definitely emphasizes the economic class comparative to the levels of family and as well as refugee. And we only have a very small window for humanitarian and other. And what you're seeing in Canada is a large number of temporary residents who have come here, as LJ mentioned, but then are unable to apply for permanent residence because they don't meet the requirements of the economic class, which largely do rely on Canadian work experience. And we'll have slides on that coming up. So the window of the 4,500 to 5,000 a year is becoming too small to fit the growing need of individuals who don't meet usual requirements. In terms of our overall planned PR admissions, permanent residence admissions, we're looking at about 1% of our population every year that we are increasing via immigration. That is the target. So that's a bit about our numbers. Next slide, please. Okay.
So this is a visual representation of the number of permanent residents admitted to Canada. The overall numbers are actually with a red graph. Will, go ahead and break down the rest of them for us, please.
No, it was yours. I missaw whose slide this was. Go.
Sorry. Yeah, my bad. So it's essentially broken down into three large categories, as I mentioned earlier during the earlier slides, and it totals to around 1% of the population, give or take, depending on the population growth rate inside Canada. So the level plans are essentially announced between 2 to 3 years every so often, and they're revised. Obviously, COVID has hit a dampener for 2020, so the number from the previous slide is a bit off, but just last week, Minister for Immigration, Marco Mendicino, came out with an announcement that we are committing apparently to the numbers, except that it's going to be delayed by 1 year. Next slide, please. Right, so we'd like to do a spotlight on the family class, and I'd like to start backwards here by going on the legal front first on how it works. So who can sponsor? So this is actually a critical break and difference between Canada and the US. I understand that in the US, green card holders are in a different queue versus those who are citizens. In Canada, there's no such distinctions. Canadian citizens and Canadian permanent residents have to queue at the same place to sponsor their family. And they can sponsor their spouse, their common law partner, which is now defined to be a requirement of 12 months of cohabitation at least, plus demonstrating conjugal relations. And then conjugal partners for those who can't actually get married, for example, if they're same-sex couples, or if they can't cohabit together for at least 12 months, say, for example, if they're living in separate countries. Then they can also sponsor their dependents who are 21 and under as minors, and then dependents 22 and over. And for those who are 22 years of age or older, they have to depend substantially on the financial support of the sponsor, or the parent rather, since before attaining the age of 22, and is unable to financially be self-supporting due to physical or a mental condition. So again, some form of disability. And then of course, there are the parent and grandparent categories. For 2021, it was announced that Canada is going to take in 10,000 applications. There's an allotment of 10,000 parents and grandparents. The lottery is actually currently going on. So how it works is you put in a notice of intent to sponsor, and then the Canadian government would draw lots from that particular pool. If you're picked, basically they'll have to screen if you qualify, and if the applicant or the future permanent resident has no inadmissibility, they get their PR. And then, of course, there's a lonely Canadian, touched on it a bit earlier. So those who are in Canada who have no spouses, common law partner, essentially immediate family, are able to sponsor any other members of the family, say a brother, a sister, or a cousin, even nieces or nephew. They can sponsor, which normally they would not be able to if it's the traditional family, the nuclear family, that is. All this to be contextualized into the development and evolution of the family class in Canada. What we see is a progressive shrinking of space for the family. As I mentioned earlier, and as Will touched upon earlier, it's announced through the Levels Plan. But in 1966, 1 year before the introduction of the Canadian point system, which we'll discuss much more deeply later, there was a push to prioritize manpower goals, in quotes. And essentially the losing class was the family class. Essentially in the white paper that was pushed around in 1966, the overriding concern was that they needed to move away from former Prime Minister Mackenzie King's vision post-war to preserve Canada's demographic character. And this was done largely by removing explicit racial discrimination in the regulation through the introduction of the point system. Next slide, please.
So to highlight when Angelica was also presenting around the 1960s, very, very similar in Canada. And as LJ just mentioned, the point system was replaced explicit discriminatory systems that existed pre-1960s, and this would target individuals from Chinese backgrounds, from Asian backgrounds, the Black Canadians. That's what existed before the point system. And then the point system essentially changed the language to things around language, to work experience, and to other terms. And we'll talk about that sanitization of race, but how it has actually been inputted into it. What happened afterwards was a paper-based system, and this is where you have paper-based applications. But what the conservative government, and this is a more, the US equivalent of a more Republican conservative government, wanted to protect the immigrants who are already in Canada and who already had Canadian work experience. So in 2008, realizing there was a huge backlog of these paper-based first-in applications, they created this new class called the Canadian Experience class that gave points for individuals who had 1 year of Canadian work experience. So this was before we actually had a express entry, larger point-based system, but we had if you met the Canadian Experience class of 1 year of skilled work experience in Canada, you can then apply. Then those applications became prioritized as opposed to those applying overseas with overseas work experience. What happened afterwards was that there was a termination of all the backlog of pre-2008 from the federal skilled worker applications. These are individuals who are overseas, leading to class action litigation, which our court actually upheld as being okay. Eventually realizing that we couldn't handle just paper-based first-in applications, we adopted the express entry model, which is the model I believe that President Trump wants to move eventually towards, given there's a precedent from New Zealand, Australia, and the other Five Eyes countries. So this is an online system now that sorts candidates by their scores. And in the next slide, LJ will break down how that scoring is done. But it was introduced, and then the government realized a year later in 2016, it was actually prioritizing the wrong individuals from the labor market perspective. They found that a lot of restaurant managers, gas station managers, and individuals that they didn't want to make the majority of the system were being prioritized. They then switched up the point allocation, which is part of how these type of systems work, where there are ways to switch up point allocations to then prioritize the ability to speak French, Canadian education, among other elements, and having a Canadian sibling as well. So now this has definitely affected who is getting PR in Canada. Where we are going now, shifting to the right side of my slide, non-express entries options, so ones that are not going through this electronic system, are definitely shrinking. And this has had a major impact on self-employed individuals, low skill, low wage individuals as the topic of this talk. And then there's also been a subsequent shift to more sectoral and regional permanent residence options. So putting the power in the hands of employers, putting the power in the hands of cities, municipalities, business associations to make the decision on who gets permanent residency, and really stripping that away from the actual worker themselves. So that is sort of the pathway that we're seeing. There is still no pathway for low skilled workers, quote unquote low skill. We both LJ and I have a lot of objection to the way that low skill is defined, especially now during COVID, as we're seeing some of them being the most valued in terms of our agricultural and medical and caregiver fields. We have a similar NOC system, so a standard occupational classification system as the US does, where we rank positions as skilled and unskilled. And it tends to be that people of color fill the positions many times in these lower skill positions that don't have access to permanent residency. Next slide, please.
Right, so this is a graphic representation, oversimplified, I'd like to say, of the express entry system, how it works. Turning your attention to the right, you'll see that there are various categories, the three buckets that I mentioned earlier, the federal skilled worker, federal skilled trades, and the Canadian experience class. So how the express entry system works is that you need to enter the pool first. So that's step one. And then step two, in order to be able to apply for permanent residence, you need to receive an invitation. So in other words, you need to be able to enter the pool. And once you're in the pool, you need to get picked. So how does that happen? So before you enter the pool even, a few things need to be considered. The first would be skilled work experience. So again, the emphasis being on the labor market requirements, which is essentially skilled work according to our policymakers. And depending on the class, you must meet the minimum skilled work experience according to the National Occupation Classification Code. On top of that, you also have language requirements, and that'll depend on how high of score that you'll need in order to be able to enter the pool under that particular category. Lastly, there's also education. Depending on the class, you may require a post-secondary education or you may not. You must have an education credentials report or an assessment report rather, if your education is not from Canada. So once you qualify under one of those categories on the right, you're in the pool. And I should note that you can actually qualify for all of them, or two, or just one. But then there's a footnote there for provincial nominee programs, which we'll talk about in detail later. But essentially what it is that each of the provinces have the ability to nominate potential candidates for permanent residence. And some of these provinces have decided to piggyback on the express entry system by awarding points for those they deem to be someone they need in that province. For example, if the province of Saskatchewan is in need of plumbers, they could probably identify candidates in the express entry pool and then send them a message saying, hey, do you want to get nominated for PNP under the Saskatchewan Immigrant Nominee Program? If they say yes, they pay a fee and they get points. Usually it's in the order of about 600 points. And to give you an idea, those scores are not far from reality, the ones that are marked on each of those eggs in the basket. And every 2 weeks, Canada does an express entry draw, about Wednesdays typically. And if you meet the cutoff, you get an ITA. Next slide, please.
And to build off of LJ's point there, a lot of the system prioritizes and gives points, and we didn't put the whole breakdown there, but on Canadian education, on Canadian work experience. So you can think of, from a temporary residence side, first the barrier of trying to get visas into Canada, temporary resident visas, which is a lot harder than in the United States. I don't know more recently, but in the past historically, Canadian temporary resident visas were much more difficult to obtain than in the United States. And then also prioritize individuals who can go and take higher level of education. For example, right now, if you are an overseas applicant, you really do need either a high level master's or a PhD, plus 3 years of overseas work experience and pretty much perfect language scores in order to even be competitive, right? So what you're seeing then is a way to filter out individuals from countries where English is not the primary language, where education systems are maybe not at the level that they are in certain countries. So when you go to the top 10 countries of citizenship, you start seeing the breakdown. And just a few things to note, LJ wanted me to note that the Philippines topping out in 2015 was a bit of an anomaly back when job offer driven gave additional points that they have now taken away and limited to now 50 points. It used to be 600 right off the gate. And then also you'll see that the countries that have the highest proportion of selection, generally, if you look at India, Nigeria, the UK, USA, Ireland, you're looking at, and even the Philippines, a lot of colonial English speaking as a first or second language countries. So through this, you can also start seeing where some of the gaps are in those individuals who are not being given into invitations to apply and being selected through our economic immigration process. Next slide, please.
Right. So this slide basically is more of a commentary. Family is an undesirable compared to economic immigration in Canada. And as I mentioned earlier, there was a guy, his name is Tom Kent. He was Deputy Minister for Manpower and Immigration. And note the compression between manpower and immigration at the time. He was in charge of basically writing the 1966 white paper that preceded the installation of the 1967 point system in Canada. Kent sought to reform the sponsorship system in order to avoid the potential for what they mentioned as an explosive growth in the unskilled labor force without inciting political controversy. Instead, it backfired, actually. There was a lot of pushback, even in Parliament, and Canada adopted a robust family sponsorship program, nevertheless. But the theme continued with family class applications shrinking. And as early as 1966, we'll see that theme, that there's this underlying assumption that family class immigration is seen as the immigration of the unskilled, the immigration of the uneducated. Quite the assumption. And I think Phil has something else to say on a more contemporary basis.
Yeah, so this is a 2018 book. It's in the resources. It's called The Family Matter by Dr. Megan Goucher. She's a professor and amazing academic at Carleton University. She wrote a quote recently in her book: while continuously identified as a priority by politicians in electoral rhetoric, family reunification has received minimal substantive policy attention, generally being treated as an afterthought. And I just wanted to highlight the modern sort of COVID sort of application of afterthought. As a result of COVID, we saw the first rushes to fixes from our immigration system were to international students, were to workers, especially in trying to facilitate as many farm workers and individuals in the medical fields. But family class sponsorships, individuals who had family class applications in process were being essentially had their applications stalled, and many now are waiting 2-3 years for their applications to be approved in order for families to be reunited. Only recently has the government, after a lot of political pressure, sort of acceded to the fact that they need to speed up processing and move things from a paper-based system to an online system and start processing. It's interesting to note that out of all of the immigration systems, we've pretty much practically moved everything online. The only one application, major application, or actually there's a couple, but one of the major applications that is still paper-based are the family class sponsorship applications. And now the excuse is they're sitting in overseas visa offices where there are not enough employees, or it's not safe to open up packages, and they're sitting. So this is a ongoing demonstration that family class is an afterthought to the economic immigration, and the filling of labor market needs is often discussed by very much the neoliberal side of immigration supporters.
Next slide, please. Yeah, and this is essentially a very powerful graph, in my opinion, that really represents as to how much of a chunk that economic immigration takes a bite into Canadian immigration for permanent residents overall. There's another interesting graph coming along with respect to how the permanent residence program interfaces with the temporary resident program. So we'll get to that in a second, but we'd like to jump on to the next slide, please, which is the pros, cons, and comparisons to the US system. Next slide, please. Just a quick disclaimer, we're not US attorneys, we're not called in any bar in any state in the US, and our comments are reflections on what we've researched, and basically we're just doing a comparative glance between the US and Canada. Next slide, please. So I've identified 4 pros of the Canadian system. Essentially, the first one being that there is no country-specific quota. And this is a layover of the 1960s, when there was an attempt, a willful attempt, to scrub race and ethnicity from the regulations. Although processing times at visa offices frequently used in place serve as a barrier. Oftentimes, for example, visa offices out in Africa would probably take longer from those taking place in Europe, for example. Then there's still the humanitarian and compassionate application that still serves as a window for those who are locked out, for example, from the typical programs that are found under the Immigration Refugee Protection Act. Those who fall through the cracks, they have the H&C application to secure PR, and it remains an option. Third would be the online process for most forms of application. But as Will mentioned, it's really telling how the family class applications are usually still paper-based. Really speaks about government priorities. It's been a while that it's been like that, and it doesn't look like it's going to change, except that COVID is actually forcing government to potentially think about it in a more, wholesome and fulsome way. 6 years in to this express entry system, we now have amazing data sets. Since it's all online, this now forms part of big data for open government in Canada. And for those who are policy wonks, this is an amazing sandbox for effective policy development and manipulation. Finally, from the applicant's perspective, the pros of the Canadian system is that it's very predictable. Because if you break it down, the express entry system, even if there are high qualifications, it's something that you can plan for. And for those who really do want to enter Canada as permanent residents, there are ways, and you can predict it. It's not based out on a random whim, less arbitrariness. Next slide, please.
And I'm responsible for sort of presenting the cons of the Canadian system. Let's start with the removals process. I know the U.S. has gotten a lot of flack and criticism for the deportations and the inhumane ways that is done. Canada actually has a very, very quick removals and deportation process as well, especially for inadmissible applicants and for individuals who have overstayed in Canada, who have studied, they've gone to school, but they haven't actively pursued their studies. It's a very, very quick removal process, and they have little opportunity to provide any evidence before removal is enforced. So we are removing and deporting a lot of individuals who fall through the cracks in our system, and largely disproportionately, they are workers, individuals who don't speak English, individuals who are caught working without authorization along those lines. There's also a huge credentials arms race. Bonus points are awarded to those who work and study in Canada, and that creates that front-end bottleneck that LJ will demonstrate through a graph. But individuals need to come to Canada first to study or work in order to get an employer-supported work permit that can facilitate the permanent residency, or graduate from a program that then supports a postgraduate work permit, which is the equivalent to the OPT in the US. And then that requires essentially a lot of upfront funds. And this is also where a lot of families become separated, because when it's a family trying to come to Canada temporarily to work or study, there is the suggestion that they are coming with a primary intent to immigrate, and that's where they're refused at the front end. So those that come into Canada very easily, who don't need a temporary resident visa and require just the electronic travel authorization, the ESTA, can definitely very easily come to Canada and begin these processes. But those from temporary resident visa requiring countries, it's a lot more work, and that's where families are often separated and the first sorting and exclusion occurs. The third thing I would say is that we are overly focused on economic immigration, and the numbers don't lie, but also in the impacts on how this has taken over really space for the conversation on family reunification. We're very focused on labor market outcomes, and all of the Stats Canada and reports on how well our immigration system is doing really is looking just at income as the major financial marker, not other elements of social integration or well-being. Of course, those are definitely harder to mark, but those are not being researched. And what we're seeing is that the employer-driven, job offer-driven immigration still remains strong. And because of that, it creates a conditional type of permanent residency. In Canada, we eliminated conditional permanent residency for spouses that used to require those who had a relationship less than 2 years to live together to prove that they were in a genuine relationship. But for employers, we still force them to work on employer-bonded work permits, lest they will lose their eligibility for permanent residence in many cases. So it does create the grounds for ripe exploitation that Angelica mentioned that she was worried about, and it very realistically occurs in Canada, along with a lot of financial exploitation from those who are third-party service providers, such as consultants and so forth. Next slide, please.
So this is a graphic representation of how it's broken down. And as I promised earlier, there would be graphs that are actually more powerful. Side by side, the US in terms of apportionment of giving legal permanent residence and Canadian permanent residence. And if you look closely, the US has about 45% of those LPRs awarded under the family class, and a further 21% under family sponsored preferences. If you look closely for Canada, that number drops to 27% only. And we're looking at the same years, actually, and we're talking about percentages. And then another focus to this would be the economic category, which takes a huge chunk. It's 58%, as opposed to, say, for example, in the US, it's 14%. Of course, as Will mentioned earlier, it's interesting because Canada is overly obsessed about economic immigration and employment outcomes, not really looking at hard or even like, researching statistics with when it comes to outcomes that are harder to measure through family reunification. Say, for example, the economy of the household, there's a long-term effect that actually comes from family reunification that is not so easily quantifiable. And yet StatsCan and immigration in Canada doesn't exactly, let's say, look over, and it's really just glossed over. Even if they profess to actually take a gender-based analysis when it comes to formulating policy and implementing them. Next slide, please.
So next,
Then
we're going to take a look at a critical lens on a couple of key questions that have been posed to us for this presentation. Next slide, please. So race, gender, and ethnicity. I know many of you are very interested in the Canadian experience and what we know and what we don't know. So I thought I'd put it into a left and right, we know and we don't know category. We know the country of origin for the temporary foreign workers. These are the workers that require the employer support. The top 5 from 2019 were Mexico, Guatemala, Jamaica, India, and the Philippines. It's important to note that Mexico, Guatemala, Jamaica are all on the seasonal agricultural worker program, a very specifically introduced program that allows workers in the agricultural field to come for a seasonal basis and then leave, but provides no pathway to permanent residency. And the history of this program was actually alongside the point system. This was supposed to be a way to control the labor to Canada and ensure these individuals could come temporarily, but not provide them any pathway to permanent residency to maintain the racist who's in and who's out, without explicitly actually mentioning it in the actual policy. So this is an example of ways that economic reasons can be exploited to limit the ability for certain individuals to apply for permanent residence on a permanent basis. So what's interesting, we looked at express entry and the numbers of permanent residents that went through the process. I think only India and Philippines on the latter half of the top 5 were in that list. So from Mexico, Guatemala, Jamaica, you don't have their representation in permanent residence, skilled permanent residence immigration numbers. When it comes to recipients on H&C work permits, these are humanitarian compassionate work permits, meaning they're the ones who are applying for humanitarian compassionate grounds. Our top 4 countries are Nigeria, India, Haiti, and Mexico. So again, Nigeria is on the permanent residence list, but you have a lot of applicants from Nigeria who are unable to. India, Haiti, and Mexico. You start having a theme of anti-Blackness as well emerge here of these countries and their individuals having to rely on programs that are outside the traditional economic routes. I mentioned earlier in my presentation, the electronic travel authorization and temporary resident visa serves already as a huge initial barrier. So the stats we have are only people who are in, and for most of the stats, it's people who have already been accepted as permanent residents. A lot of silence on those that are actually refused. And we know that visa offices, for example, in Africa, have up to 90% refusal rates, where in Europe, they have up to 90% approval rates. So there's clear discrimination on the face, but because of the way that the stats are developed, we don't really see that in the analysis of our families and our permanent residency. IRCC does have what's called a gender-based analysis. So we have a gender-based strategy that is touted. Unfortunately, it's dated to the 1970s when those who were on this committee, of Women's Advocacy Committee, were only of a certain melatonin. But what we're trying to encourage the government to do more of, and we're starting to see more of this push, is to take more of an intersectional lens, to look beyond just gender as how many women have been accepted by their express entry program versus how many men, but to actually look at racial elements, country of origin elements, class elements, sex and gender elements beyond just gender, but bisexuality, look at trans rights. But a lot of that, the data is slow to be developed and slow to be prepared. So overall, I'd say race has been sanitized. We've used skill, language, and other markers to replace our old explicit individuals from this certain background or this certain country cannot be allowed. And we have utilized visa processing as a way to discriminate without having to put it specifically in our legislation. So what we don't know race-based data. Our immigration department specifically does not collect race-based data and makes it clear in their annual reports they don't have that information. We don't have the disaggregation of data. So even though we know who's coming on LMIAs, we don't know the difference between the low-skilled and the high-skilled ones. We don't know how many of them are farm workers versus how many of them are, skilled tech individuals. That disaggregation has not been done, so many of the problems can be sort of hidden in the data. We also don't know who's been impacted by those excluded from express entry and unable to apply. We tend to publish data on those who have been approved, but we don't tend to publish too much data on those who have been refused or rejected, and I believe for very specific reasons. Finally, we don't know how gender is a determinant in the refusals of our applications, and we don't know how intersectionality is being applied beyond surface level training that I've found through government resources. It seems to not rear up in any judicial decisions or in our tribunals. So really, it's still a singular gender lens with some comment on how many women and men are being accepted in the system, which in our mind falls short. Next slide, please. So this is just a quote from, again, Megan Goucher's book, but the privileging of the nuclear family breadwinner model in our point system and family class continues to reproduce specific understandings of nuclear family that cut across sexist, racist, and heterosexist lines. And it really does marginalize and make secondary the family class with respect to independent migrants. And I know LJ we didn't have full time to go into all the details. This could be a 3-hour presentation, but in the economic stream of express entry, there are an increasing and growing number of applicants who are actually in families, but because of the way the points allocate, they have to actually apply individually and keep their family members abroad in order to get enough points to then immigrate. So we have different point systems for single applicants versus applicants that are a family with a spouse. And because the spouse are awarded points on their own economic factors, their language, their Canadian work experience, etc., it makes sense for some individuals to leave their family members abroad and try and re-sponsor them, furthering the time of family separation and barriers on that in that respect. Next slide, please.
So this slide is actually really interesting as it traces the reliance on work permits against the permanent residents admitted under the economic class. So you'll see that until 2004, 2005, that there is a little bit of a congruence between the issuance of work permits for temporary residents, the one in red, and then the permanent residents that are awarded in blue, colored in blue. So what's going on here is that it's a clear demonstration that the Canadian economic classes for permanent residents don't necessarily correspond with the needs of the Canadian economy. So it's always been a hammered and well-used argument that the economic programs are supposed to be there in order to address Canada's economic needs. But again, there's an overemphasis, especially through the express entry system, to prioritize people who have high skills, high education, or higher language skills that sort of disenfranchises a lot of people who don't necessarily have those, but are still essential in the Canadian economy. And as Will mentioned earlier, COVID has not only highlighted this, but underscored this a lot by showing to us that those essential workers who are working as orderlies or caregivers in long-term care facilities, those who are manning the agricultural posts, making sure that the harvests are done, and making sure that the food is actually collected, those are generally work permit holders, and they have no pathway to permanent residence, not through the current iteration of the economic programs. So if anything, this graph is a demonstration of that failure. And 2 points I'd like to bring up here. Essentially in 2013, between 2013 to 2015, you'll see that there's a dip in the reliance on work permit holders. This was when there was a lot of scandal into the abuses of the temporary foreign work program in Canada, which essentially forced the Conservative government at that time to make dramatic changes to the temporary foreign work program in Canada, and in terms of how the labor market impact assessments were done back then. But then keep in mind that in 2015, Canada launched the express entry system. So you'll see a sudden and dramatic uptick in the reliance on work permit holders from 2015 to present. Even as the blue line goes up, the red line skyrockets. It shows that while express entry on the whole may be considered as a success by using those normal indicators that StatsCan uses, it's not really talking about this giant gap between temporary temporary workers and permanent residents. Next slide, please. So how do temporary residents transition to permanent residents? That's a really good question. So again, 4 points. The first point being is that there is still an over-reliance and overemphasis on employer support when getting the labor market impact assessment, because there is a pathway. If you have a job offer in Canada that's backed up by labor market impact assessment, you get extra points. Though for the most part, for these lower skilled, and with that in air quotes, is usually not enough to actually be competitive in the express entry system. But then there's also the open work permit pathway to permanent residence, and there's an overemphasis on educational routes. All of this basically creates what Will had touched on earlier, which is the conditional permanent residence. And probably the extreme case would be that of Australia, where permanent residence is essentially bonded to employers. Basically, this leads to a lot of employment situation abuses. I can personally relate to this. I have a cousin in Australia who went through the same process. Thankfully, she had the means. She actually was able to just pay off the bond and say goodbye to her abusive employer. Then there's also arranged offers of employment, and it's also very crucial in bridging those people who do not normally qualify under express entry. But yet all of this is not enough. Even if you have the bridging open work permit that actually creates a little bit of flexibility, and as mentioned in the slide, it's a lifeline for transition from temporary residence to permanent residence, it's still not flexible enough. I've seen too many cases where the system is not able to capture a lot of people due to processing delays, and that through no fault of their own fall through the cracks and would now have to rely on the humanitarian and compassionate grounds. Finally, there are 2 questions here. Who is able to apply for PR under express entry, and who's left out? So again, it really bears to mind the overemphasis on a high skill, high education, high language skills, which really leaves a lot of people out of the rain. Next slide, please.
All right, we took a little bit longer than we anticipated. We ran it through at 35, but this is we took about 45 minutes. Apologies for those who have to stay a little bit later through their lunch breaks and so forth. Yeah, we're open to some questions and answers, and we're happy to fill in any gaps that our presentation may not have covered. We do want to mention that these presentations usually would be about 2 to 3 hours if we want to get into all of the details and really present the case. So we tried our best to do an overview. There's definitely a lot of things we didn't talk about. So if there are any questions of interest, we'd love to field them and to give our thoughts at this time.
And I'll just reiterate, we will be sending slides and recording of this. We're going to go over a few minutes. I know some people have to drop off now, but we will send the full recording. So do chat your questions for any of the 3 panelists. And I think while we wait, Angelica, I'm going to give her an opportunity to respond to your presentation for a minute.
Well, first of all, I just really want to say, Will and LJ, thank you so much. This is what an important presentation, and I think so timely too, as we continue to discuss immigration reform in the United States. One thing that I did want to express is that in the United States, and I know probably the same in Canada, a family migration has also been the source of individuals who become incredible economic contributors. They're entrepreneurs. They come with incredible skills. So while they come in through the family-based system, their contributions are immense economically. And so we can go through, the founder of Google. We can talk about how individuals who have come in, Tulsa, you could go through so many that it would take us forever to go through this, who have come through a family-based system and then employ their skills in so many other ways. So this idea that only an economic point system will lead you to those economic contributions, I think is false. I'd love for you to comment on that.
Well, do you want to take first crack?
I tend to need another couple seconds to think about things, so maybe you go first and then I'll follow.
Okay, sure, no problem. There's actually a lot to be said about that. I'm Exhibit A. I came into Canada through the family class, and that's not too long ago. A lot of my family in the US, they came through the family class, and they're well established. So I totally get where Angelica is coming from. And what's interesting is it's true. In Canada, there's an over-reliance on the economic, or overemphasis rather, on the economic categories. But at the same time, the express entry system tends to over-prioritize those who are employed. So in a way, there's an argument to be made that it stifles entrepreneurship. For example, if you could go back to slide number 16, Megan, if you don't mind. That's the colorful graphic. Yeah, there you go. So if you go there, if you look at this very closely, I mean, most people who would fall under the Canadian experience class would require Canadian employment or employment in Canada, physically in Canada. But what about those who want to do, venture capital investment or for example, do a startup? And these are, incredible economic motors and engines that don't necessarily get captured under the express entry system. In fact, I always counsel my clients that if they're gunning for the Canadian experience class, do not be self-employed, because legally speaking, they could do that, but that's not going to equate to points, and that's just going to, endanger their PR pathway. Will?
I'd add on my end too, and this is I'm really impressed by all your advocacy efforts, because I also think from the Canadian parallel perspective, we have a lot of migrant worker organizations. We have a lot of, big corporate business funded immigration think tanks. But in terms of family class advocacy, or an organization just dedicated to family class advocacy, we do have a bit of a gap, and it seems to be individual applicants that have to form these ad hoc groups. Without that data, without that research, and with the government, policy-wise, and the historical foundation being, we can't track families, we can't track how many families are helping other families, and then lead to this chain migration. They've sort of made an excuse that because we can't track it, we don't need to track it, and therefore there is no argument there. But I think, as you mentioned, highlighting, as Angelica mentioned, not only highlighting individual cases, but really tracking the data and showing these ties and showing these links, I think we can provide a much stronger case. And one thing I would definitely emphasize too, on parent and grandparents specifically, I'm fighting several appeal cases now where I'm trying to argue the role and importance of grandparents or even older applicants. LJ didn't mention it in too much detail, but our system also has a huge age discriminatory factor. So after the age of 45, you get 0 points for age, and your chances of immigration on a permanent basis are pretty much down to zero. The role of older parents and grandparents in supporting the family unit and allowing the other members of the family to become established or economically viable and strong, entirely missed in our system, entirely missed in the policy and discussions. So there are a lot of room for improvement, and I think in this way, the U.S. advocacy might even be ahead of the Canadian advocacy. So we're learning a lot just from being here and learning and speaking to all of you.
Thank you so much.
Thank you so much. I know Angelica has to leave. I might keep you, Will and Lou, for 5 more minutes, but I want to thank Angelica so much for presenting today. And okay, so that was actually going to be my first question. It was about parents and grandparents, because in our system, which does allow unlimited parents to become lawful permanent residents, and we obviously have a healthcare system that's very different from yours. So these proposals of it being a temporary visa for parents puts them in a very precarious position vis-a-vis the healthcare system. Some proposals require them to buy very, very expensive private insurance. But otherwise, if they end up going to the hospital, they end up in a huge amount of debt. So I'm wondering if your healthcare system covers those special visa holders within the healthcare system.
Will?
Did you want to answer this question? Okay, I'll go for it.
Sure.
Is it $1 million? Like I haven't. It's been a while since I've done the last super visa, but I think there is
I
a
think
requirement
they're
for this.
requiring 150,000. Although it's been a
Is
while
it
since I
more?
did one myself.
In
Yeah,
It might be more now.
in
In
insurance
yes.
coverage?
yeah.
You're right.
Sorry. Actually, I can pull it up in about 2 seconds here. LJ, why don't you talk first, and then I'll get the answer to
Sure,
you in
no
about 2
problem.
seconds here.
Thanks. Yeah, so those who are applying for super visas essentially would have to purchase private insurance, and that's very explicit of a requirement. A lot of my clients actually prefer not going through the parent-grandparent super visa for temporary reasons, for a variety of reasons. Essentially, that is because of the obscene amounts that they'd have to put out initially to get their insurance coverage in Canada, because they have to purchase insurance in Canada. Whereas if you're traveling here for 6 months or maybe even a year, your credit card travel insurance might actually, be able to cover that, and they just like come in and out, right? But of course, you're going to be subject to examinations at the border. Will?
It's $100,000. Sorry, I don't know why I thought about a
Okay.
million. I've been clearly my mind is in a different space. But $100,000 coverage at a minimum. But again, we still have the visas for parents and grandparents. A big barrier again becomes overseas visa offices, because with parents and grandparents, you have to show that there's a temporary intent to still visit Canada. And for a lot of applicants, especially from the global south, where they may be, widows, or they may not have other family members there, the rest of their children and siblings are all in Canada, there is a presumption that they're coming for immigration purposes. And then you will see these offices refusing on that basis, regardless of an argument of dual intention that you hope to go back. They will do that. So that is a primary way that we have been selecting which parents and grandparents are able to reunite. And the visa offices play a huge role in sorting. And this is not explicitly racist in the written in the law, but in effect, you have overseas visa offices making very, very different decisions on very similar type cases based on race, ethnicity, country, board.
Thank you. Okay, so I have another question. And it seems like it's multiple parts. I'm under the impression that the immigration system in the US is much more messy. Do we have a presentation on US immigration? There have been some, we certainly can do one for Value Our Families in the future. I think on the messy front though, one of the reasons ours is messy is because once you are out of status in the US, it becomes very, very hard to ever become permanent, or if you're deported. So maybe you can respond to, my understanding is it's a little bit easier in Canada on that front. And then the other part is about efforts to change immigration laws in Canada. If there are effort, I think you touched on this, but if you want to speak more to efforts to change immigration laws in Canada.
Sure. I'll deal with the restoration question first. When you lose status in Canada, you have a 90-day period to restore your status. So that's definitely a very good policy. I don't know if an equivalent one exists in the United States on that front. We also have temporary residence programs, which serve as a Band-Aid for when you are inadmissible, but you need a temporary respite from it. And that is an option to apply for. And then many of these applicants, if they've been in Canada long enough, will start applying for humanitarian compassionate grounds permanent residency, because they cannot meet a requirement of the Act from inside Canada. Historically, if you made that application inside Canada, your success rate was around 40 to 60, so upper 50%. But if you were deported or removed from Canada, your percentage success when you're overseas goes down to single digits. So there's a huge effort once you are out of status in Canada to try and either normalize or seek permanent residence options. But once you are removed or deported, the chances of coming back as a permanent resident, unless you have another ground, do become much lower on those humanitarian and compassionate grounds. LJ, you want to add anything on that first part?
Oh, you answered it pretty well. I mean, if there are any efforts being, I think the second part of the question is efforts to change immigration laws. There's been a lot of advocacy work on the family front. One of our bigger mentors, Jamie Liu, who we had as a professor for immigration law, both Will and I, or I think it was just me, I can't remember. But anyway, she's part of a group that basically advocates for this quirk in Canadian regulation. It's called 117.9D in the regulations. And what it means is that if a person in the family class was not declared as a part of your family in a permanent residence application, then basically you are barred from sponsoring them forever. I had once a person who came into my office and said that he was counseled terribly by an immigration consultant that he should not declare his live-in partner with whom he had already formed a common law relationship. And the reasoning was because if you do that, you're going to go back to the back of the line in the skilled worker pile and probably wait another 5 years because processing backlogs were so bad at the time. In effect, he came here, became a permanent resident, and lodged a sponsorship application. But it's on record that he came in here as a single individual and then made tax filings that he was actually in a common law relationship. He was basically roasted in his own fat. It was very unfortunate. There's no remedy except for the humanitarian and compassionate grounds. It's an alternative remedy, but as Will had touched upon earlier, if you're not in Canada, your success rates are really, really low. So it's not really a real remedy if you think about it. So there's a push to actually change these things. And in 2019, there was a suspension of this particular provision in the regulation, thanks to the hard work of advocates. And thanks to the potential lawsuits that were going to be filed in federal court against the government that basically made them be a bit more proactive to change the laws. And it's still a pilot program at the moment, but we're hoping that this will become a permanent solution.
I think the only thing I would add to the question of what can be done, I think it definitely requires advocacy on multiple fronts, right? There are the legal advocates who need to break down the provisions and try and reform them, amend them to make them better. There's also definitely a role for the political advocate as well to talk about the real in-person, real life impacts. And we're seeing that advocacy going on with a lot of the families that have been separated. They're sharing their stories online on Twitter in very public forums, standing outside immigration offices, begging for their families to be reunited. But I would have to say that one of the big challenges with advocacy in Canada is still that the labor market, population, I would say it's the population growth economic argument of immigration still trumps, and I hate to use that word, but all, right? And I think that the real advocacy needs to occur on that level between those who argue for rights for all, which is I think a very important piece, but the middle ground to sort of connecting the family and the economic class and seeing that overlap. And Angelica really targeted that in her comment, that we need to see families as being very beneficial to the economic argument as well, and bridge that gap that seems to have been formed from like it's either this side or that side of the spectrum.
Great. Well, we're way over time. Thank you so much. Your presentation was perfect. Very, I think the right amount of detail and answered all our questions, though it's a lot to absorb. So I'm sure we'll contact you with more questions. But thank you so much, Will and Lou, and we'll be in touch.
Thank you.
Thank you. It was a pleasure.